Good morning, Mr. Havlin, Mr. Thompson. Welcome to the First District Court of Appeals. The first case on the docket to be argued this morning is N. Ray J.C. Mr. Thompson, how much time would you like for rebuttal?
5 minutes, Your Honor.
Very well. You may proceed when you're ready.
May it please the court and counsel, this is one of those cases that just sort of leaves me wondering how we got here. Why did we end up here? Because everyone in this case knew that the gun in this car belonged to Antoine James. Everyone understood that JC didn't bring the gun, and whether they wanted to believe Antoine forced her to take it, they knew he was the one who gave it to her. Yet for some reason, Antoine gets away scot-free, and JC is convicted of adjudicated of carrying a concealed weapon. In response to our argument that JC's adjudication should have been reversed under Rule 29 F2D, the state argued that JC's adjudication, if it was reversed on those grounds, would prove that Antoine was right, that juveniles would not get in trouble for these things. I say it proves that you should just make a juvenile take your gun because you'll get away with it. JC was in
was he, and I assume it's outside the record, but was he prosecuted for anything related to this?
It's outside the record, but the record that I obtained when we had the question about correcting the record does not reflect anything, any convictions related to this. And the JC, she's put in this untenable situation. She's just getting a ride home from work. She ends up in a car with a brother who wasn't supposed to be the one picking her up, and he's got a loaded gun. Police are actively pulling them over, and her brother gives her the gun. Is she supposed to assume he wouldn't do anything violent if she refused, or that he'd go easy if she rolled down the window and told police he had a gun? Or could police have done the reasonable thing and charged Antoine with having weapons under disability, improper transport of a firearm, or even concealing the weapon on his sister? She deserved to have her conviction reversed under Rule 29 F2D because police simply went for the wrong person. And we also argued about
are there any cases where appellate courts have stepped in under that rule to do what you're suggesting? That just seems a pretty dramatic remedy to me.
It is, and I don't have any cases where I can point to of a court doing that, but it is an option, and I do think that this particular scenario is one of those rare ones where it is an abuse of discretion to not recognize that JC deserved a break. But beyond that, we also argued about the charging document. The state filed a complaint here, and it says that JC knowingly had concealed on her person a deadly weapon. And then it says, to wit, a black Smith & Wesson 40 caliber handgun. Concealed weapon statute 2923.1.2. It's broken up into A, 1, 2, and 3. 1's the deadly weapon other than a handgun. 2 is a deadly handgun other than a dangerous ordinance, and 3 is the dangerous ordinance. We know we can eliminate 3, but we're left with language that involves both 1 and 2. We simply argue that the complaint language says deadly weapon, so the state chose to charge under A1. And while the facts say handgun, the state never charged in the alternative or amended to A2. And while a handgun is a deadly weapon, the statute explicitly excludes handguns from A1. So the only conclusion is the state charged under the wrong subsection, and JC was adjudicated under the wrong subsection, and therefore her adjudication should be reversed.
Was there any effort by the state to amend at any point?
I checked the transcript again this morning, and I could not find any reference to amending the statute or amending the charging document. regarding the evidence, the last thing I wanted to talk about, Antoine's record. The reason Antoine's criminal record was not allowed into evidence was that the magistrate ruled it was irrelevant. And the state argues that a criminal record can only come in for impeachment purposes and that Antoine wasn't a witness. Our position, first of all, is that Antoine wasn't there to complain about his record coming into evidence. So there's really no grounds to call it impeachment or improper impeachment. The second, the defense being raised here was a duress defense. And one way to go about proving that is circumstantial evidence. And Antoine's record and his prior violent history were circumstances relevant to JC's actions.
I read I appreciate you all collaborating on getting that exhibit to us. And I looked over that, and yes, he's got a number of charges and convictions on there, but the only one that suggests violence to me is the armed robbery, and that was like 2009 or something. So like the fact that he's had disorderly conduct, drug charges, OVI, like how is any of that probative that he would, resort to violence against his sister?
Well, I would first argue that there are a number of weapon convictions after that. So he continued to have a weapon. And the point is simply that in her mind, she knows her brother has a gun, or knows that when you have a gun, he gets in trouble. And this isn't a scenario where it's a law-abiding citizen with a handgun, and all you have to do is disclose it to police because you have a valid CCW license. So it's relevant, even if the court were to find later that it wasn't decisive, it's relevant to show JC's state of mind when she's put in this situation. If there are no further questions, I will reserve the remainder of my time.
Any further questions?
No.
Okay. Thank you for your argument. We'll reserve the rest of your time. Mr. Havlin.
Good morning, Your Honors. Counsel Alex Havlin on behalf of the state. I'll just respond briefly to the last thing that Mr. Thompson talked about, the criminal record. Judge Bergeron, I think your question kind of got to the state's point. I mean, I understand that he wasn't a witness. I understand that this isn't really an impeachment circumstance. That's just what that case from the other Ohio Appellate District kind of said when describing the analysis that you go through when you look at introducing the criminal record of a non-party, non-witness. The problem is just what you pointed out, Judge Bergeron. We're just throwing a record out there to say, see, he's a bad guy, and therefore he must be doing bad things now during what happened in this case.
So, Mr. Havlin, you don't think that would be at all probative to show JC's subjective fear of her brother?
Your Honor, I think it could be somewhat probative. I think it's less probative when, in response to a direct question, she says, he has never in my life threatened me. So while he did an armed robbery, like you said, Judge Bergeron, in 2009, it wasn't his sister. There's no evidence in the record whatsoever that he's ever done anything to her. So I think this is the classic example of, while somewhat probative, it's also just open for wild speculation that he's a bad person, therefore he must be doing more bad things. I think this is the genesis of this rule, and a reason why, if you look at the US v. Lucas, the Sixth Circuit case, they held that 404B evidence should generally apply in cases where such evidence is used with respect to an absent third party not charged with any crime. I think it's because of just this sort of uncertain or indefinite nature of that evidence. It doesn't really do much.
You're not taking the position that a third party's, like the threatening party in a duress situation, that their criminal history could never be admissible and relevant for duress? Are you, you're just saying that
Not
this
never.
right?
No, Your Honor. I think specifically in this case, the fact that when asked directly when she was testifying, did your brother threaten you that night? She said no. And on then recross or cross, I forget which one, the state asked, has he ever in your life threatened you? She says no. I think with those two, that's direct evidence of her history or relationship, I guess, with this brother. When that is, had she said yes or something, then maybe we get closer to a situation where, like, okay, maybe he's doing this to everybody in his life. Maybe he threatens the whole family. I just think, I don't think we get quite there with those two direct answers.
Well, let me ask you this question. Like, I understand all the legal arguments that you've raised in your brief. But what about Mr. Thompson's point that he opened with, which is that this is a situation where at least it seems that both the arresting officer and the magistrate all agreed that it was the brother's gun, and yet she is taking the fall for this exactly as he intended. Like, what does that say about our juvenile justice system if the actual perpetrator gets off on this and, you know, the young sister pays the penalty for his bad acts?
It's not an ideal situation. I'm not here saying like, oh, it's fine. And I know, in appellate practice, open-ended rhetorical questions aren't the norm, but what's the alternative, I guess, is what we're left with. Nothing, just saying, all right.
Well, no, I think the alternative would be like, go prosecute the brother. I mean, it seems like they had plenty of evidence that they could have used.
I respectfully I think if it's in her pant leg and we show up and say like it's his, I'm not confident in that case. Is that the best result? I don't know, but it's, if this gun were sitting in a console, we could charge everybody in the car with it. There's precedent for that. I'm unaware of any precedent where a firearm has been located in a different person's pant leg and we've charged someone else with it, absent some, I don't know.
Well, but you would have direct testimony from the sister and maybe someone else that was in the car that said this is what happened, and the officer seemed to agree with that.
We may have that. We also very likely would not. I mean, if the argument here is that she's so scared of this brother that she took this firearm and put it in her pant leg, then I highly doubt she's going to show up to any type of official proceeding or sign any type of affidavit on a complaint. It's a terrible situation. I'm not saying, hey, this is great, but I stand by the comment I made in the brief and what Mr. Thompson opened with. What are we supposed to do if we just let them give it to another person and then nothing happens to them? I don't think that's the appropriate result either. It's not a good situation, but the facts are there was a loaded firearm located in her pant leg. There's no time, there's no case law that says, well, she didn't possess it for an adequate amount of time. There's nothing to that fact. And the record, I think, is very clear. I don't want to talk about the duress defense a lot unless there are a lot of questions. I think she took this because he said nothing will happen to you. She testified to that, and that she believed her big brother. I don't know. I think it's a dangerous precedent to set if we just then allow that to happen, regardless of the other issues. I can, if there are no more questions on that, in terms of the charging instrument, argument, I'm uncertain. So the complaint lists just 2923.12. It doesn't enumerate any further in the section. It does say both deadly weapon and a handgun. At no point in the record am I aware of any confusion that arose during the trial or during the proceedings. I don't know. I'm kind of uncertain, I guess, at what's being argued there.
Let me ask you this. I don't have that document in front of me, but you're indicating that it lists 2923.12A2.
No, no, it does not. It stops at point 12.
At point 12.
Yeah, it doesn't go any further.
But it identifies a handgun.
It says, the relevant portion says, did knowingly have concealed on her person a deadly weapon, to wit, black Smith & Wesson 40 caliber handgun with serial number, and then it lists the serial number. So it says both deadly weapon and handgun. I don't, again, this just gets back to my general question about what either the notice problem was or any prejudice that may have been suffered. But I think, if there are no more in-depth questions on that, I'm happy to submit on what I've filed in the briefs. And I guess if there are no other questions on anything else, in terms of concealment, I think, the court is well aware of the case law on concealment. The record in this case, the officer who was actually pulling her out of the car testified that he at no point saw this gun, and he's the one dealing with her. The other officer who eventually saw the rear sights said that he only saw them once she began to drop her sweatshirt and cell phone that she was holding close to her abdomen. So I believe that the state proved concealment on that point. If there are no further questions on anything, I would just ask that this be affirmed.
Any other questions?
No.
Okay. Thank you, Mr. Havlin. Mr. Thompson?
Your Honor, I'd just close out by saying that sort of the overarching question here is, do we do what's right or do we do what's easy? I don't think there's any precedent to set here that about you get away with it, or if you're the juvenile and you take a gun, you get away with it because the other person put the gun on you. I think the point is, it might be a little harder to prove the case against Antoine, but the case is against Antoine. And if you have a juvenile who willingly takes a gun, then you prove the case against the juvenile and Antoine. It's just not.
Mr. Thompson, let me ask you this. How do you propose the state prove the case against Antoine? Because my recollection of the transcript was that at the traffic stop, the police said to Antoine, "You're putting this gun on your sister. Why don't you admit that it's your gun?" And at the same time, she was unwilling to say or tell the police that it was his gun, despite the fact it was on her person. So how do you propose the state proves the case against Antoine when the police just suspect that it's his gun? They probably know, but that's not good enough. You don't have a witness to prove it. How would you prove that case?
Well, we know what happened when push came to shove with JC. She testified and told the truth. And maybe that's the power of charging her, is to ensure she testifies. But to let him get away with it, and the evidence showed he slowed down, and I think they said he crawled to a stop over like 100 yards. There's some circumstantial evidence there that that's the period of time that he was trying to hide the gun and failed, so he gave it to JC. So, I mean, I've certainly
Did the arresting officer witness any movements of that would be indicative of that?
I believe he used the word furtive movements. I know I cited.
It's a very nebulous concept.
Correct, but that's the language that we use when talking about these things. And I mean that certainly wouldn't be the first case to be proven by furtive movements and circumstantial evidence that at a period of time, Antoine had a gun. He had it in a car. He had it in a position that was loaded or could have readily been made loaded, and he wasn't allowed to have a gun. So maybe the right thing is to charge everybody and sort it out, but I don't think the right thing was to adjudicate JC. And for those reasons, we ask that the court reverse her adjudication or remand for a new trial.
All right. Thank you both for your arguments this morning. We appreciate them. A very interesting case. We'll take the matter under submission and get out a timely written opinion. Hope you both have a great day.
You too.
Your Honors.
Good morning.
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 All right. Good morning, everybody. Welcome to the First District Court of Appeals. The next case to be argued is the N. Ray M. children. As this is a parental termination matter, I just urge counsel to refrain from identifying anyone's name and just use initials or the child, father, whatever's easiest. So, Mr. Whitfield, you'll lead off as appellant. Would you like to reserve any time for rebuttal?
I should be pretty brief, but I'll reserve 4 minutes just in case.
4 minutes. Okay. And my understanding is that Ms. Wood and Ms. Bradbury are going to split time.
Yes, Your Honor.
Okay. Very well. All right, Mr. Whitfield, you may proceed when you're ready.
Your Honor. Good morning, everyone. May it please the court. My name's James Whitfield. I represent father in this matter. This case does have a lengthy history. This family was involved with Job and Family Services for some time. And throughout that time, both parents had some significant challenges. My client in particular would dabble with drugs over the years. But there's a couple of things that were found in the decision that are inaccurate, saying that he didn't visit his children, he hadn't spent time with his children. He consistently tried to visit his children. He had been clean for some time as this case went through, which is noted in the decision and in, I think, both arguments that I read. But the issues that we reviewed, there was a situation arose and basically with his children, which upset him deeply. And we have two issues presented for review today, and those two are interconnected. And just to be clear, the first was that I asked for a continuance on Mr. Pickett's behalf, simply because he could not be present that day. I allude to it. He found some information out the morning of the hearing that troubled him deeply. He just wasn't able to make it down. I'm in the courthouse now, down here at the court.
Mr. Whitfield, he was given the option to appear virtually.
Correct. Judge did. I'm sorry, go ahead.
So it's not that he couldn't come down to the courthouse, it's that he just wouldn't be there for the hearing, even though he had the option to do it from his living room.
His issue was that he couldn't contribute. He wasn't in a mental state where he felt that he could contribute to his own case, where he could testify, where he could pay attention and give me notes and give me signs and say, challenge some facts that may have come out. So I don't know if whether he could have physically got here or participated by Zoom, he wasn't in the right mental state to protect his rights as a father. And that was his issue. I'm sorry, I saw you were about to say something, Your Honor.
Go on. I'll save it for later.
Okay, you're fine. I'm sorry. I know we've been doing Zoom for a while. I don't like Zoom. But so you're right. He was given the option up here via Zoom, but he could not make it. And I asked for a continuance and it was denied. And I asked for a continuance on two grounds. First, obviously, we wanted Mr. Pickett to be there. Excuse me. We want a father to be there. And counsel for a mother also asked that he get a continuance so that his client could be there. Again, we kind of discussed it, Your Honor, briefly. My client's request for continuance was denied, despite the fact that he couldn't be there, but also I requested a continuance due to the fact that approximately 2 days before the trial or the permanent custody hearing, we received an updated GAO report. And I believe the local rules require a 7-day notification before that a report can testimony.
Mr. Whitfield, one of the problems that seems to me in these parental termination proceedings is just the difficulty of scheduling and getting everybody on the same page to, be in the courtroom at the same time. And as a result, like a lot of these proceedings just last, way, way, way too long. I think most people would agree with that. And so like we have, upheld like a parent's right to be there when, for instance, like their car unexpectedly breaks down on the way to the hearing and, the court denies them a continuance. But I just worry about if basically anytime someone doesn't, and I don't want to discount any sort of mental challenges that father may have been dealing with, but anytime someone doesn't feel like it, it allows the proceedings to be extended, which ultimately, it's not like it could have just been set the next day. We really have to think about like the child's interest or children's interest too, and how long these proceedings can drag out.
And I understand, Your Honor, you're correct. These cases, just the type of cases they are and the amount of attorneys or professionals who have to put this on the schedule, a lot of times these cases are pushed out and it is hard to find dates. And that's one of the factors that the Supreme Court talks about that we consider when we decide, where the court decides whether or not to grant a continuance. We actually took that into account that day where I just wanted a continuance. I didn't want to continue the whole case. That was my original request, but feeling that was going to be denied, I asked for an opportunity for Mr. Pick, for my client to present his case. And anyone can participate. We didn't get into how that would look, but we were willing to inconvenience ourselves, so to speak, at the convenience of others, not to require others to be back in court where they could have participated by Zoom, but where a father would have had a chance to at least present his case. And again, the two kind of dovetail together because part of the reason he felt that way on June 17th, which was when the hearing was because the report was issued on June 15th. So he had just found out some information immediately preceding the trial date, and had things been done properly, we submit, he would have had at least a week or so, 7 days, to maybe process that information and maybe accept what was going on or what those recommendations may have been for us to try to combat the allegations that were made in that report.
Mr. Whitfield, was there anything on the record to indicate that, I don't know if you were trial counsel or not, but the trial counsel hadn't read it or the trial counsel wasn't prepared, despite the fact that the report was filed 2 days before the hearing?
I did. I was trial counsel, and I asked about the continuance. I didn't specifically say that I was prepared, and I didn't specifically say that we would like time to combat, some of the facts that were listed or that were contained in the report. I can't remember if it was the state or if it was the GAL. Someone said that the report was essentially identical to a previously report that had been filed, but that wasn't the case. It couldn't have been the case because there was testimony, and the judge noted it in her decision. She explicitly talked about the wishes of the children, and according to the GAL, who filed a report on June 15th, the children felt a certain way and said certain things, and these were based on these allegations, and these feelings were allegedly based on circumstances that had just arose. Because the second part of why we're here this morning, when the children were actually placed in father's home, and then there were some issues in the home. We acknowledge that, but at one point, the children began making allegations against father, allegations that father to this day still denies. But those allegations came after that initial report had been submitted. So this report in the testimony of the GAL was based on new information. And even if I had been prepared to perhaps argue it, some of this information was new and I hadn't known it, and I hadn't discussed it with my client, who had found the information out, like I said, a couple of days before that. Literally, I think it may have been the day before, and he just was not in the mental state where he could contribute or help me to present his case the morning of the 17th. And so again, if everything had been as it was supposed to be, as dictated, we would have had at least a week to go through that report, to go through the allegations that were made, to go through the statements and the alleged wishes of the children, and neither to address those accordingly, or if my client, because at one point my client was almost willing to reach an agreement, we could have, that may have been an option. But because the way the case played out, we weren't given that option. And my client was never able to present his side of the story. We touched on in our brief, and we touched on reasonable efforts and the situation, how that changed when the children were placed with him on an extended visit, where he felt like he wasn't getting the support. He felt like, he was kind of left on an island. And I can't obviously testify for him, but that's the kind of information he would have presented that day. It was said and noted by, I think, the worker that day, that the family received intensive services, the family received, additional counseling, things of that nature. But from the time that these allegations arose, 2 weeks later, the children were removed from his home. And so I don't know how intense the services could have been in just 2 weeks. What kind of efforts were actually made to make sure that these children could stay in the home with their father? And their father, again, I talked about it earlier. I know I'm running low on time, but the father had changed his life. He had done a lot. He's been clean and sober. There were several drug tests that were administered throughout the case that allegedly came back negative. And I say allegedly because we didn't see those drug tests. The day of the trial, we heard that, I was told that there was a drug test where my client failed, but we didn't see that either. We didn't receive any confirmation either way. But again, that was new information that was alluded to, and I believe that was contained in the GAO report as well. But father did not have a chance to combat that. He wants to present his case. He's, he doesn't totally understand the process. He tells me they can drug test me now, I can pass the test. And what we're asking essentially is just for a chance for him to present his case. I understand that these children need some stability. They need to be placed. But as counsel for mom alluded to, and I'm in agreement with them, at that point in time, they were where they were just as they are currently situated. They weren't in limbo. They had been placed already. They were comfortable. Like I said, we try to deal with any inconvenience to counsel and the professionals by allowing we ask that their portion of the case go forward, that everyone who was there need to present the case, do what we want to do, but we just ask for some time to present father's case. And that's all we're asking for today as well, Your Honors.
Thank you, Mr. Whitfield. You'll have 4 minutes of rebuttal after the appellees go. Ms. Wood, Ms. Ryberry, who'd like to lead off?
I can begin, Your Honor. If it would please the court, Patsy Bradbury on behalf of Job and Family Services. In regard to father's request for the continuance, the state respectfully disagrees with Mr. Whitfield's assessment of the matter. Father was notified in April that the agency intended to proceed forward on its motion for permanent custody. So this was not a surprise to him that was the plan for the agency. At that point, the children had been removed from his home. So a report from the GAL was filed that was nearly identical to the one that was filed in June. And I will let Ms. Wood speak more to the GAL report. The only changes to that report were the children's placement. The GAL, both the former and the current GAL at the time, still advocated for the grant of permanent custody. So this was not new information to father. Father was aware of the court's aid, had a meaningful opportunity and notice of the hearing, chose not to participate in person. The judge asked if he would participate by Zoom. He declined to do that as well. He was provided with a meaningful opportunity to present his case. He declined to do so. Even after the hearing, the judge permitted father to file a supplemental brief if he chose to do so in order to further support his arguments, which he did not do. Father did not present any testimony or evidence at trial which would have changed the outcome. So the court was within its discretion in order to deny father's request for continuance. It is important to note that this was not the first time these children had been in care. They had been with the agency in the agency's custody since October 2nd of 2018. So these children had, at the time of trial, were quickly approaching 3 years in the agency's custody. So to deny the continuance was proper for the court to do. As your honors have noted, Judge Hendon, as a sitting judge, does not have a regular docket. So her availability is even less than a regular magistrate's in this case, which also contributed to some of the delays in getting this matter moving forward. In regard to the reasonable efforts argument, the agency did put in intensive in-home services from the time the children were placed in father's home in the fall of 2020, so approximately September or October. The children were not removed until March of 2021, in part because father could not manage their behaviors. Some of the difficulty in father managing their behaviors is because he was not providing them with their prescribed medication to help manage their behaviors. Father,
Ms. Bradbury,
yes, Your Honor.
and I realize these aren't the facts of this case, but if there was evidence that father had diagnosable, mental condition that he was struggling with, and for instance, maybe on the day of the hearing, he has a panic attack or something that's debilitating and kind of prevents him from moving forward, like, would that change the analysis at all if he had kind of physician substantiation of the reason for not being able to go forward for the hearing that day?
If it were a legitimate reason, Your Honor, I believe the court could have taken that into an account. This family has been involved with Job and Family Services for an extended period of time. Father had not provided or during any assessments was he diagnosed with such a significant issue. Father's over the course of time had been a substance abuse issue, and testimony did come out at trial that he did suffer a relapse after the children were removed from home. So I can leave it to the court's discretion to theorize whether or not it was a substance abuse issue, but the caseworker did testify that he was positive 2 days prior to the beginning of trial. And again, it's important to look at what is in these children's best interest. The agency provided father with intensive in-home services well above what is normally provided. NIAP, the program providing the services, were in the home 3 to 4 times a week to help manage the children's behavior because there were concerns about father's ability to manage. Father at some point even—
Counsel, and
Yes.
just to be clear, that testimony about the fact that there were intensive services and that went above and beyond the norm, that was undisputed, right?
That is correct, Your Honor.
Okay, go on.
And in addition to the services, father was provided with food vouchers and other assistance to make every effort to maintain the children in the home. But at the end of the day, what is important here is these children's best interest. They had been in custody at the time of trial, approaching 3 years. Their mother had abandoned them. She was also offered the opportunity to participate, by Zoom if she chose to do so. She also declined to do that and had not been a factor in these children's lives for years. Father had indicated that he had a volatile relationship with JM, the older boy in this case, that he did not want him back in the home. As a matter of fact, is what he indicated to the worker at some point in time. The other 2 children, the younger children, had been placed in foster placement, the younger of which he had been in that foster home before, so he did have a bond. No other family members had come forward seeking custody of these children. Both GAL reports advocated for permanent custody as being in the best interest of the children. And as the court can review, these children had an extensive custodial history. The older children, this is now their 3rd go around in agency custody. And the legally secure permanent placement, father, despite his best attempts, was just not able to do that. There were concerns for his substance use, housing stability, and his ability to maintain these children. So the agency believes at that point in time, it was in the children's best interest, and that the grant of permanent custody did meet that need for these children. Father had indicated that a further delay would not prejudice these children, but at 3 years, Your Honor, any further delay is of significant concern to the children and could have, again, they're unstable. The older child was in a residential facility. And part of that is due to the long procedural history of this case. These children needed permanency, and unfortunately, despite father's love and care for these children, he just could not maintain that. So the agency still believes that the grant of permanent custody was in the children's best interest. And at this time, I can defer to Ms. Wood, who can go into more detail about the guardian's recommendations. Thank you, Your Honors.
Thank you. Ms. Wood, you have about 8 minutes.
Good morning, Your Honors. May it please the court, I'm Julia Wood, the attorney guardian ad litem for the children in this case. On behalf of the children, I respectfully request that the decision of the trial court granting permanent custody be upheld, as it was supported by ample, clear, and convincing evidence, and it is in the children's best interest. I think most of the legal part of the continuance has been addressed, but as it pertains to the GAL's report, there were no significant changes to the GAL report other than the wishes of the children. And that was specifically to the 2 younger children, that they no longer wish to live with their father, that they wish to stay in the.
But isn't that a significant change? If the children are now changing their minds, and I mean, that does seem to impact kind of the overall calculus of how the case is going to go forward.
The children had a tendency to go back and forth, and the older children were pretty consistent in their determination that they did not want to stay with father. I believe specifically it was the 2 younger children that changed. And father at the time maintained a relationship with their foster mother and maintained a relationship with them through that relationship. And so specifically, yes, I guess you could consider it a significant change. However, it was not unknown to father, so significant that it would impact his ability to participate in the proceedings the day of trial. It had been relayed to him via myself and I believe the caseworker prior to the filing of the GAL report.
You mean you had relayed to him that the children wished no longer to live with him?
Yes, Your Honor.
And that's on the record?
I did not testify in this hearing. So I guess technically no, it's not on the record. As it pertains to the best interest analysis of the children, I think Ms. Bradbury covered a pretty significant portion. The children have been in the care of the Hamilton County Job and Family Services for an extensive period of time. They are in need of a legally secure permanent placement, and despite father's best efforts, as well as JFS's best efforts to maintain the children in the home, father was not capable of maintaining the children, in part due to his denial of their mental health medication, his housing insecurity, his inability to maintain the older child. There was also another older child that is not in this complaint, in this case here now. She was placed in a planned permanent living arrangement after the disruption by agreement of all parties. The other 3 children indicated that they did not wish to go home, and mother has abandoned these children on multiple occasions. And despite father's best efforts of working services and the intensive in-home services that were provided to him, he was unable to provide a legally safe and secure permanent placement for these children. Based on these reasons and the reasons that Ms. Bradbury has stated previously, this GAL requests that the court uphold the grant of permanent custody as it's in the best interest of the children.
All right, thank you, Ms. Wood. Mr. Whitfield, you have 4 minutes.
Thank you. I think the arguments we just heard kind of highlight the whole point. This case was lengthy. This was a 3-year case. And so for 3 years, give or take a few weeks, my client did everything that he needed to do in order to get these children placed in his home. And when I say doing everything he needs to do, he maintained sobriety. he upgraded his home. He obtained housing that was large enough for him and his children. He, like I said, he passed all his drug tests. He did whatever was asked of him. He did all that. And then 2 days before we're going to trial for permanent custody, he finds out his children have changed their mind and no longer want to live with him. And this wasn't something that he was made aware of months earlier. This was something he found out almost like he said 2 days before the trial date. He found out his children allegedly saying that they don't want to live with him. And they're basing this on these allegations. He's selling drugs out of his home. He's always drinking in the house, things that he wholeheartedly denies to this day. So when he found that out, exactly prior to hearing, in a place where he could contribute to the case. Again, he found this out less than 2 days before. He told the worker, and this isn't on the record because he wasn't at the trial, but I believe I fell back. That's what he reported. And just to the last point, I know I just don't have a lot of time. Once he did all the things I just noted, getting the housing, making sure he is financially situated, when the children were in his home, he felt alone. And when I say he felt alone, there were no services offered by JFS. He received vouchers, but he didn't receive any consistent financial support, no food stamps, nothing in that support. He didn't get any child support. So he was doing this all on his own. He was trying, we talked about year to medication prior to placement with father and since being displaced from father. The child just did not want to take his medication. That can't be blamed or placed entirely on father. They have issues probably as we sit here today. And so say, well, now we're going to take the kids from you and we're going to try to provide intensive services, quote, air quotes, for 2 weeks when the kids will venue at you for maybe 2 months, but you didn't get any report at all, any support at all. Those efforts aren't reasonable. But now at the last minute, right before a trial day is coming up, now all of a sudden we can go in your house and we can provide intensive services and we're bringing over backwards to help you. But where was the assistance? Where was all this support the 2 or 3 months when things were going downhill? It wasn't there. So these reasonable efforts that allegedly took place, they aren't reasonable because you can't just rush and go out for the final week or two and then say, well, we did everything we could do and throw our hands up. Because for 3 years, this man did all he needed to do, all he could do to get his children back. And if he lost it the last couple of weeks, the wheels fell off when he didn't get any support. And when he did find out his children are making allegations against him, in his estimation, false allegations against him, he kind of lost it. So what we're asking the court to do is remand this, allow him to present his case. His case may not change the outcome, the ultimate outcome, but the children are somewhere safe. The children aren't in the wind. The children actually still see their father. I'm not sure to this day, but they were seeing their father because the foster parents, I think it was alluded to, work with this man. He's working with everybody. He's worked with everybody. He just wants to present his case.
All right. Thank you, Mr. Whitfield. We appreciate your argument. Thank you, all counsel, for the arguments today. We'll take the case under submission and issue a timely written decision. So we hope you all have a great day.
Thank you, Your Honors. Everyone have a good day.
Thank you.
Thank you, Your Honors.